on scene at the time. The act was malfeasance or misfeasance, and the act was corrupted behavior. The corrupt behavior, Your Honor, the precursor to that would be evidenced by what was stated to the victim prior to the assault and battery taking place. I believe that that's enough to show that it was an assault. There was no evidence that was presented to refute any of these elements, and that we would ask that it be bound over on at least one count of misconduct in office or any other charges that this court may find appropriate.
What statute are you relying on for those elements, please? Since
Your
you
Honor,
didn't include it in your complaint, which I find makes the complaint on its face deficient, but...
Your Honor, these are actually off from case law, which is People v. Carlin, on remand, which is 239 Mishap 49, as well, Your Honor, as People v. Cotu, 459 Mishap 348. It's a common law charge of misconduct in office. I believe it does state on the complaint, Your Honor, that it is 750.505.
That just talks about the punishment. That isn't the elements of the offense. You better research your case law and find out what law they were relying on. Your argument, Mr. Mertz?
Your Honor, it's the defense's position that this case should not be found over, that the elements of misconduct in office have not been shown by the prosecution. One of the elements is malfeasance. The proofs today did not show any malfeasance on the part of the defendant. There is absolutely no evidence that the claims made by Mr. Brown and his wife that he was slammed onto the hood of the car, that he was bent over the hood of the car, that his head was mushed into the car, that his back was bent over the hood of the car. It's obvious from the video, Your Honor, that none of those claims, none of the allegations made by the Browns in this case are borne out by what's plain to see on the video. The undersheriff viewed the video. He listened to what Mr. Brown had to say. The undersheriff couldn't find any correlation between what Mr. Brown said happened and what the video showed. The undersheriff, who is a trained police officer, an experienced police officer, who knows what an assault is, testified that there was no assault in this case. And that's part of the reason why he didn't move forward with Mr. Brown's statements, even if Mr. Brown hadn't, or had, despite the fact that Mr. Brown did not want to file a written complaint, the undersheriff testified that along with that fact, the fact that he didn't see an assault take place was part of the reason why he didn't move forward with it. The state police trooper that detective sergeant that testified stated that he also did not find that the statements of Mr. Brown and his wife matched up with what was on the videotape. Without any evidence that the defendant actually committed an assault, and Your Honor, you can watch the videotape and you have. It's clear from the videotape itself that there isn't any evidence of an assault. That, along with what the defense would characterize as untruthful statements by Mr. Brown and his wife to both the undersheriff and the Michigan State Police, demonstrate that there is no assault in this case. There also has to be some type of corrupt intent, and the case law states that that intent has to be, that the act must be done with a sense of depravity, perversion, or taint. We would submit that there's no evidence of that whatsoever in this case. The prosecution presented no evidence that any contact that occurred was based on a corrupt intent on the part of the defendant. In fact, the undersheriff testified that it was because the contact occurred because the defendant thought he was going to be spit on, and that Mr. Brown himself admitted to the undersheriff that he could see why the defendant thought he was going to be spit on. Either way, the defendant did not use any type of assaultive force. There is no malfeasance. It was not done with corrupt intent. And so we don't believe the elements are satisfied. We would also state, Your Honor, that the facts surrounding how this case ended up in your courtroom today are compelling. The prosecutor was provided the video of this incident last August. As early as December, the prosecutor had prepared a binder and presented it to the state police regarding this incident. In January, the prosecutor made statements to the state police that he had watched the video and that he thought that an assault had taken place. But at that point, the prosecutor decided to not go forward with charges, did not go forward with an investigation. And why? Not because he didn't think it was criminal, but because he thought that the defendant's work performance had improved. What difference should that make? Do we want the prosecutor charging cases based on his evaluation of somebody's work performance? I don't think that's the standard. I don't think that's appropriate. I think this case is in your courtroom not based on evidence, but based on some type of personal animosity by the prosecutor. Based on that, Your Honor, we would request that you dismiss all the charges in this case. Thank you.
Any final remarks, Mr. Sims? Hearing none?
No, Your Honor, thank you.
Defendant is charged with a two-count felony complaint. Count one charges common law offenses, misconduct in office, that is the felony. Count two charges him with misdemeanor assault. This stage of the proceedings is what is known as a preliminary examination, and at preliminary examination, the prosecuting attorney's burden of proof is to present sufficient probable cause evidence on each of the elements of the crime to convince the reviewing magistrate, which is me, that the crime was committed and to give me reasonable cause to believe that this defendant, John Keathley, committed it. I've sat here and listened to the evidence, and certainly parts of the video are disturbing in terms of the way the arrest of the complaining witness was conducted, and the contact, I'll call it, between the defendant and the complaining witness at one point certainly got heated. But I'm required to make a finding on the felony offense only. The misdemeanor offense, the assault, is not cognizable in the circuit court, so I cannot make a finding on that. I have to rely on the charged felony, which is a common law offense, not typical to the type of charging we usually see in this court, and usually not reliant on the attorneys pulling elements out of case law, but instead relying on statutory violations. What is disturbing to me about this is the progress of this case, and I think defense counsel has hit it right on the head. It appears that this matter happened last May, last August. Apparently the prosecuting attorney started looking into it. The disturbing parts to me are the parts in December and January where the state police are called in to do an investigation. They work together with the prosecuting attorney on this investigation, and at that point make a determination, as I understand the testimony here today, by consensus not to proceed. I think to anyone looking at this case, the code words for there isn't enough to go on for this case to proceed. Then there are the disturbing remarks about, well, we're not going to proceed because his work performance has improved. Again, I totally agree. How can that be a reason for deciding what crimes are charged? Finally, it's brought to my court in the condition that it's in, basically without what I would call sufficient probable cause evidence for the prosecuting attorney to proceed on this. I find that the elements were not made. Misfeasance or malfeasance in office, what does that mean? According to the undersheriff who investigated the matter, no assault occurred. According to the state police, whose initial review of the video, and the prosecuting attorney's initial review of the video, no assault occurred. The individual who alleged to be assaulted hadn't even proceeded on any kind of formalized complaint. So where is the misfeasance or the malfeasance? And there certainly isn't any corrupt intent. As far as I can determine from what was presented here today, Detective Keathley and Deputy Avery were conducting what would be a relatively, on domestic violence, believe me, there are no routine investigations, but a routine investigation and a potential arrest. And other family members complicate the factors, and the police have to work for their safety on those circumstances. And I think based on Under Sheriff Halliday's description of it, his investigation looked at all those aspects and determined assault hadn't occurred, did not deny the complaining witness the opportunity to proceed with the complaint, but the complaining witness did not proceed with it. So I'm going to dismiss this case without prejudice. Certainly the prosecuting attorney is free to rebring a case once it's dismissed without prejudice. Under those circumstances, I'm going to make the finding that there is insufficient probable cause for me to bind this case over to circuit court to stand trial. So the dismissal will be, as I said, without prejudice. I'm not going to make any finding on the assault charge because I'm not required to, nor can I, because that is a charge that's cognizable in my court and would have to be tried in a situation where the burden of proof would be beyond a reasonable doubt. So with that understanding, I'm dismissing without prejudice. Defendant's bond may be returned to him after bond costs have been deducted. Thank you. Court's in recess.
Thank you, Your Honor.
Thank you, Your Honor.